Tonight, we begin our series on the Tyler Robinson case. Tyler Robinson, 23, stands accused of the high-profile, politically charged capital murder assassination of conservative activist Charlie Kirk on September 10th, 2025 at Utah Valley University in Utah. But before we talk about the courtroom, before we talk about the evidence, the motions, the media coverage, the death penalty fight, or the legal strategy, we got to start with one question. Who was Charlie Kirk?
A favor, please be respectful, okay?
Hello. So I have a few leading questions before my main one, because I have to be honest, I don't really know that much about you. So would you say that you're very religious?
I am religious. However, every one of my political positions is defensible from a non-religious perspective.
Okay, great. So I was under the impression that your beliefs on abortion were stemming from your religious beliefs.
Well, at the core, that is correct, but I can get that it is defensible from using reason and prudence, as I have done the last couple of
Cool. So you're not trying to illegalize abortion based on the Bible?
Well, no, not based on the Bible. My personal conviction comes from the Bible. I want to make abortion illegal because it is the only applicable extension of laws we already and standards we already have in the West. Correct?
I'm sorry, can you maybe rephrase that?
Eliminating abortion is the only logical step while we apply the standard we already have in this country to unborn life. So we have murder laws.
Yes.
Therefore, murder laws should apply to unborn life as it does to born life.
Okay. So, again, reiterating, you're not trying to instate laws based on Christian beliefs because that would be unconstitutional, right?
Well, again, sort of, but no, I am not using scripture to defend my beliefs. However, my personal convictions start with scripture, but the political views that we're talking about here are all defensible using reason and Western tradition.
Okay. So, great. That's all I needed to know, that you weren't trying to instate laws based on Christian beliefs, because I would not be able to support anything that was so blatantly unconstitutional. But thank you for clarifying that for me. I had a whole thing ready, but I guess that wasn't necessary. Thank you so much.
Well first of all, just tell me more about how you view politics, or what. Is that okay? Or if not, and feel free to walk away. I'm not here.
Maybe not in this crowd.
That's okay. Thank you. What's your name?
My name is Archer.
Archer, thank you for coming up, and I hope you have a great day.
Thank you so much. Thank you for clarifying.
And let me just say one last thing. I could tell you probably have a negative impression of Christianity, maybe. I hope one day we can earn back your support to making Jesus Christ your Lord and Savior. I'm sorry if the church has failed you in that way, because I do have strong religious convictions and beliefs, and there is a God who made you and loves you, and he sent his son to die for you.
Her name is Mom.
Okay, well, thank you. I do appreciate the candor and the courage to come up here, but we will pray for you. Thank you.
Okay.
That was Charlie Kirk doing what he did, and that is how he died. I want to get your thoughts on Nicole before we continue on. He was assassinated because of that something like that, right?
He was assassinated because some lunatic took what he said and made it hateful, because he personally was offended, because his personal lifestyle flew in the face of everything that Charlie stood for. And he found it so egregious that he said that this type of hate, exactly what you just saw Charlie do, needed to be eradicated. And this is how Charlie Kirk lost his life.
Yeah, at Utah Valley University. Here he is moments before on that tragic day. Shelly, we all covered this on Poppin' Politics, the tragic assassination of Charlie Kirk. Can you just talk about that day?
Yeah, that day I remember it vividly. I was at work, and but nevertheless, it was so Unbelievable. That's the only way I can think of. It was unbelievable. Initially, I thought it was an AI. At the very initial, when the video started going, I just didn't believe it. But nevertheless, here we are. Some 7, 8 months later, and it has happened. It did happen. It was real. It was not AI. That day was a pall over not just our country, over our world. It was a pall over the world. Charlie Kirk, and I'm gonna say this, and I don't mean it in jest. In a sense, he was as iconic, if you will, as Michael Jackson was. And I'm not saying that as from just a jet. I'm just saying his reach was that wide, that far. Many people over the world still mourning his death, of course, but he had such a reach. I like that initial clip because Charlie Kirk, he showed what Christians do, not for likes, not for clicks, not to look good, not to look in the limelight, but he did it. And he treated everyone that came to that microphone with the utmost respect. Yes, he pushed back. Yes, he stood firm. He contradicted them, but he also treated them and always, always, always invited them into the grace and love and the forgiveness of God.
Mm-hmm. Yeah, folks, we want to bring to you all not just the legal breakdown of this case, but how did we get here? Who was Charlie Kirk? Why was this assassination so not just tragic, but just so shocking to the world, honestly? Take a look at this next clip, the reaction that multiple people across politics, across media had to the assassination of this man.
Oh, good God. Yeah. He's dead. It's official. It's from the COO of Turning Point, who just tweeted out, "Dear Turning Point USA family, it's with a heavy heart that we, the Turning Point USA leadership team, write to notify you that earlier this afternoon, Charlie went to his eternal reward with Jesus Christ in heaven."
I have just received news that I'm not even going to repeat because I don't have it. Confirmed. We will confirm what's going on. And when we have solid information, we will bring it to you.
As I just mentioned, Charlie Kirk has died at a hospital in Utah. At the risk of sounding repetitive, Charlie Kirk was an incredible man. Charlie Kirk was a good friend, not just to me, for anyone who holds a microphone and anyone involved in politics, anyone he came into contact with. You'll hear it repeated on numerous occasions that Charlie Kirk was my friend. And that doesn't make either any one of us unique. It makes Charlie Kirk unique because every single one of us would get a text, would get a direct message, would get a call from Charlie, encouraging us, congratulating us, complimenting a conversation or a segment. In a business that is full of ego, in a business that is full of competition, Charlie Kirk was a true friend.
Charlie inspired millions, and tonight, all who knew him and loved him are united in shock and horror. Charlie was a patriot who devoted his life to the cause of open debate and the country that he loved so much, the United States of America.
All right. Again, that was the reaction to this public assassination. So let's take it down. We want to talk about the case now up until today. Okay. Prosecutors have laid out a strong circumstantial and direct evidence in public filings and hearings. So let's talk about what's occurred so far. Nicole, I want to start off with you on this. We have a motive and intent. So we know notes and messages allegedly left by Tyler Robinson, including one to his romantic partner, roommate Lance Twiggs, saying something like, I had the opportunity to take out Charlie Kirk and I'm going to take it. Is that right?
Yes, there are several text messages, explicitly one text message chain where Twiggs asks him very specifically, did you do this? And he says, yes, I did this. So this is some of the information that the state has secured by using a limited, let's say a limited immunity, or they call it in Utah, a use or derivative immunity, which means they're going to get him to testify, even if he says that he's going to take the fifth, that this particular type of immunity overrides that fifth, because they can't use his words to have a criminal case against him. So now what's going to happen is all of those text messages are going to come in. He talks about where he hid the rifle, the towel that he used, how angry his father is going to be because the gun that he killed Charlie with, allegedly, is his grandfather's gun, something that was handed down to his father. So all of this is in this text message thread between him and his so-called roommate / lover, Lance Twiggs. This is very damning evidence. It's hard to back away from this type of excited utterance, because he said it within moments of this murder and then continued to say it days after this particular murder. So this is really, really strong evidence. There were some other things that came out, a preliminary ballistics report that said that the bullet that they found was not an identical match to known bullets that's been used. There's some pushback about that, because once a bullet hits a bone, all bets are off of what that's going to look like on the other side of that. But again, that was a preliminary report. The defense is doing its job. Mm-hmm. It's raising question after question. It's leaking stuff to the media. It wants cameras out of the courtroom. It wants no audio recordings. They're doing everything they can do to try to slow down the progression of this case. In fact, we haven't even gotten to the part of the case where the state lays out all of its evidence. We haven't even gotten there yet. It's motion after motion after motion after motion, but it's really starting to heat up now, because this judge has said there will be cameras, there will be audio, everybody needs to get ready. But tightly controlled, released to the press who's leaking. There will be sanctions against people who leak, and it's already gotten pretty messy with the leaking.
Yeah. And talking about charges, Shelley, so we're looking at aggravated murder, a capital offense, discharge of a firearm causing serious bodily injury, obstruction of justice, witness tampering, and violent offense in the presence of a child. So prosecutors intend to seek the death penalty. What else do we have here?
So I want to go back a little bit because Nicole put out a lot at one time. So how we got here to this point. Number one, of course, Tyler Robinson was arrested. I think it was September the 11th or 12th, around that time frame. During this time,
before you go, we do have a clip of the arrest. I'm glad you brought that up. Let's take a look here of the clip of the arrest here, of the sheriff who talks about the arrest.
He said, "Hey, I know who Charlie Kirk shooter is. I know the family through religious association, and he's in Washington County now, and we're working on trying to get him to come in voluntarily." During that phone call, some information was provided about Tyler potentially having some suicidal ideations, was en route to a remote area of Washington County. The parents convinced him not to do that, and conveyed that they would stand by him and help him surrender peacefully. So at that within the hour, my friend drove Tyler and his parents to my office, where he was greeted by plainclothes detectives. So
As doing something good here.
Yeah, outstanding. He deserves full credit. I think that a lot of it's just the community relations, right? So Tyler's family trusted this individual. They knew he was involved in law enforcement at some point, and enough community involvement there that they trusted that they could go to this individual and he could contact me directly, and that we could facilitate a peaceful, calm, relaxed surrender, put it that way, right? Make him comfortable for a couple hours, make sure he has water. No communication until the lead investigators arrive.
So that the family of Tyler Robinson contacted a former detective, not the other way around. He also drove the whole family to the sheriff's office, and it was Tyler's mother and father that turned him in, not a family friend. That was pushed out initially. It was actually his parents who turned him in. This family friend, who was a detective, simply coordinated it. And as you can see, the sheriff confirms everything stated in the charging documents, almost word for word. So I'm sorry. So what were you saying, Shelley?
Right. So after Tyler was arrested back in September, they have, of course, in the process, there are all these motions that are filed, affidavits, indictments, all those, legal processes. Then at that time, back in September, October, I think it was, the judge, I think his name is, I forget his name is, this skips me. Anyway, Tony Graff, yes. He placed a gag order on the process, basically. That gag order applies to both the prosecution and the defense and any other witnesses that may come into play, if you will, as well as court staff. So the law enforcement as well. So the gag order covers everything. The gag order basically says that all of these parties are prohibited from speaking to the public about evidence, witnesses, any kind of forensic results, because that's going to come up as well, which is where we are today, what Nicole was talking about, and any kind of opinions about Robinson's guilt or innocence. Basically, if you are directly and maybe indirectly, to however far out it goes with this case, you cannot speak to the media for or against, no matter what. You're not supposed to speak to the media. So what Nicole had mentioned, basically in the last month, at end of May to now, there has been a preliminary process, a preliminary hearing where you refer to the ATF report in particular. The ATF report came out, forensic report, basically stating that they cannot rule out that the bullet fragment was the actual fragment from the bullet that shot or that was used to murder Charlie Kirk. They can't confirm it or deny it because the piece of the fragment was that messed up, basically. Okay. That damaged, right. Go ahead.
So let's back up a little bit. So you talk in late 2025, early this year, we had the pre-trial motions and the hearings. The motions on shackling, they had a motion on that, on civilian clothing and sealing documents. Again, we had Judge Tony Graff. He was balancing public access versus the fair trial rights, but they have found that there will be cameras in the courtroom.
Right.
Now we're here, 2026. We have ongoing evidentiary and procedural hearings. And you mentioned the ATF bullet analysis disputes. And so what I want to ask you is, because I'm a little confused on what you both were saying about now. So I think it started in May, June. There were defense motions to seal parts of the preliminary hearing, appeals on camera rulings, and the recent contempt claims against prosecutors. So what exactly are they saying that these prosecutors did? I think we may have a clip for it. Do we have a clip?
Okay, go ahead.
Let me see here. One sec. Okay, here it is. So here's a clip that talks about what the defense is asking. I'm sorry, what the defense is asking to remove the death penalty from the case after the prosecution discusses evidence about the case. So this is what it is. This is clip 1.
The man accused of killing Charlie Kirk was in court today, and his attorneys are asking a judge to hold prosecutors in contempt for comments made about the case during a media tour. Kate Gardner breaks down what happened.
Tyler Robinson's team wants the death penalty taken out in this case after a deputy Utah County attorney discussed evidence with national media like TMZ and Fox News. 23-year-old Tyler Robinson is accused of shooting and killing political commentator Charlie Kirk on September 10, 2025, while Kirk attended a speaking event at Utah Valley University.
The violation was intentional, or it was so reckless, and I will use the legal phrase extreme recklessness, that there's a very fair inference of intentionality.
But the prosecution explains their reason.
Have there been other circumstances in this case where you have declined and your office has declined to speak with the media?
Yes.
And if you declined in other circumstances, why did you not decline in this circumstance?
And so we got those reports. And in those other circumstances, we had persons concerned about what they perceived as misinformation. And my conclusion was, we're not going to go out there and talk about those things because, quite frankly, I didn't know whether or not how the defense would use that information. And so I decided, no, we're not going to comment on that kind of stuff.
Okay, so there have been other circumstances where you said, nope, we're not going to talk to the media about X, Y, and Z.
That's right.
But in this case, you made an analysis and said, yes, we're going to talk to the media in this case because of how important the issue is.
Yes.
Robinson's attorney, Richard Novak, argues this could taint the jury pool and, in turn, has a request for the judge.
I think that the number one remedy in this case, Your Honor, is for this court to preclude the state from seeking the death penalty against Mr. Robinson.
The judge is set to make a ruling on the motion on June 22nd.
All right, so let's break this down because I'm still a little confused.
Mm-hmm.
I want to understand, why are they saying it was wrong for the deputy prosecutor to discuss evidence with the media this time, and then why I did not understand the prosecutor's response as to the difference between not discussing it previously, but he decided to discuss it now.
Okay, so it was wrong. The defense is alleging, that's the motion that they are making. So again, in the processes, when court process, you don't just get out indicted and have a trial. There are all kinds of things going on up until those dates. That's number one. Number two, the prosecution, I'm going to say allegedly, but they spoke to the media. That was against the gag order. The gag order said no talking, both sides, to the media for no reason, unless and until that has to be taken before the judge and all parties meet and say, okay, maybe, can we do this? Yes, no, maybe so. That did not happen. So the defense is basically saying, in short, that the prosecution going to the media violated the gag order. And number two, it really sets up, bias. I'm going to say bias. I'm going to say bias to the public and information out there that has not been presented in court. So it's
now I understand that.
That's why.
So what I don't understand is why
they're asking for in the motion, which I think is unreasonable, but what they're asking for in the motion is, because the prosecution did this, the consequence, we're asking for this to happen, and their consequence is to take the death penalty off the table. That is what the judge is going to rule on, I think, on the 22nd.
Well, Nicole, why is the prosecution saying it seemed to me that they were saying there's a difference between in the past where they said we're not going to talk to the media, and why they chose to speak to the media now?
Well, back in April, when the judge first put out the rule also states, this gag order also states that the state or the defense can speak to the media if there is misinformation leaked. And this is what happened. This ballistic report was a preliminary report. It's not the final report. It is nowhere near finished, at least in that particular form. And the defense leaked it. They've been leaking little things left and right through not necessarily people who are sealed under the gag order, but people who are maybe 2 or 3 degrees away from the defense. So maybe Lance Twiggs' cousin's sister said something. Do you know what I mean? So the information is leaking. The prosecution stance on this, and this is what Attorney Ballard said on the stand, is that when there's that much grave misinformation, the state reserves the right to correct it and only correct it. They didn't say anything else except for address directly that ballistics report by saying it's a preliminary report. Everything that you see in there in TMZ and Fox, he did not answer a lot of questions. I'm here to talk about the ballistics report that you guys are saying are absolute truth. And I'm going to tell you it's preliminary. It says preliminary. It's, the information in it is preliminary. We're not going to show you our hand until we have to. We've not gotten to that part of the trial yet. And now that the defense has gotten their panties in a bunch, for lack of a better term, this is not the first time, but this is the second time that they have tried to either, one, strike the entire state team. They didn't want any of the prosecutors that have been assigned to the case to continue the case. They made that motion in May. What they want now is for the judge to strike the death penalty because they're saying that the prosecution leaked. Here's the problem with that whole scenario. The prosecution is saying we didn't leak. We just corrected the misinformation and we reserve the right through that gag order to do so. And that's what Chris was saying on the difference between now and then. If he would have released it before the judge, made that particular rule about the gag order, he would have absolutely been in trouble with the judge for what he's done. But what he's saying is somebody was trying to influence the jury pool by releasing this report. And sure enough, he's absolutely right. They released a preliminary report. Candace Owens picked it up, and all of her minions slid across the internet and said, oh my God, he's innocent. He's a patsy. He's a this, he's a that. Not one time did they mention that this report was preliminary. Not one time did they talk to a ballistics expert who said, when bullets run into things like bones, human tissue, it changes the way the bullet looks. It changes. Maybe you only get one part of the rifling and not the whole bullet. I mean, there are lots of things that can happen when bullets hit things that it's not supposed to, which for me, in my humble regard, is a paper, target on somebody's range. But when you shoot someone in the neck and it goes through a bunch of bones, things are going to happen to that bullet that the manufacturer did not intend. So it's going to be hard to identify. The preliminary report says that, and that's not uncommon. That happens in a lot of shootings. The bullet looks different on the other side of the shooting. With all of that said, what's going to be very interesting is if the judge allows that rule to continue. Every time the defense leaks something, or even if the prosecution leaks something, will the judge allow the opposing counsel to go to the media and correct it, or will he issue a final gag order that says absolutely no information, period, across the board? And striking the death penalty, they do have precedents for that. Now, I don't think that's going to happen, but they do have precedent for striking the death penalty.
I do want to offer this, okay? Now, I know Nicole said the reports that I've seen, there are no conclusive reports stating that the defense leaked that paper, that document. That's number one. This is why they have the motions, because the defense is basically saying, no, we did not, because we filed the motion that the prosecution responded to it. That's number one. It's no defensive conclusion that the defense did it, but the prosecution did comment on it. And legally, there's a difference, apparently, from what I have done in my research. Again, I am not an attorney. There's a difference between leaking. Anybody can leak it. Anybody. It doesn't even have to be the legal teams. Anybody can leak it. But commenting on it is what is covered under the gag order. So anything that needs to be commented on should be met with the judge to decide. You cannot just go on your own to respond to whatever media, however incorrect it is. So that's why you have to go to the judge, and the judge has to say, well, this may be an exception, and both sides have to be there in front of that judge in the chambers, the defense and the prosecution, before the judge, saying this is what was leaked, this is what we might want to say, or can we say it, judge, or not? So there has been no definitive, again, saying that the defense did it. No, because the defense filed the motion, so that doesn't even follow logically. If they leaked, that they would file the motion against the prosecution, just logically. Number three, all of the parts that you were saying, Nicole, about the evidence, all of these things are supposed to take place in court, under trial, under oath, under process. This is why they're not supposed to be debated by the legal team in the media. The public can do whatever it wants. Journalists can. And number three, I like to have props. I wanted to show you all. This is a bullet. Okay, what people call a bullet. This is a bullet. This is a box of ammo. Okay, this is a box of ammo. This is one of the bullets. All right, now people see this. Most people see this whole thing. When a bullet has certain parts. The casing is what is extracted once the gun is fired. The bullet is the projectile that goes through the barrel, okay, to hit whatever target. The fragment, the casing is what— hold
it up, we can't see it because your name.
The casing is what the ATF, the casing, the outer part. The casing is what the ATF has, or fragments thereof. Because it was so damaged, they could not determine if that fragment— this is a whole piece, of course— they could not determine if that fragment, the casing, the outer shell, was actually the part of the bullet that came out of— again, this is an example— out of this particular box. They could not determine that. They just couldn't determine it because it was so damaged. That doesn't mean it didn't. That doesn't mean it did. Okay. That's what the ATF ruling or determination came to that report. So again, motions are filed all the time. It's normal part of the process. Motions are filed all the time. But basically, a motion says, Judge, can we do this? Or I'm saying this. Is this allowed? For the most part, that's a short way of looking at a motion.
Well, to kind of help us figure out, has this happened before in cases? Is this something that happens, and what might be the outcome? We have joining us tonight former Attorney General Curtis T. Hill Jr. Is joining us to kind of break this down. He's been backstage listening to it all, so we're going to bring him forward now. How are you tonight, General Hill?
I'm very fine, ladies. Thank you for having me. And I have to say, I don't think you need me at all. I've been backstage listening to your analysis, and it's quite fascinating. You certainly have done your homework. You understand the issues, not just understand the issues. I think you articulated a very good analysis of what's going on in the case. So I'm very pleased to listen.
Thank you so much. Well, we're going to bring you right in, and want to start off with what we just left off. So we would love to hear, your experience on how this generally goes, what might happen, what might not happen when we have a situation like this where the defense says they didn't leak the document, they're under a gag order. Prosecution says they were commenting on misinformation that they believe was leaked by the defense. Have you seen this before, and what generally happens in these types of cases?
Well, we do see it quite routinely. I mean, first and foremost, what we're after in a trial is a fair trial. That's the most important thing. And when you balance the fairness of the trial to the defendants, it's also a fair trial to the state. That's balanced against the public's interest in knowing what happened. And as a former prosecutor myself, I put the public's interest in knowing what happened at a very, very distant second place to the interest of the trial being a fair trial for the defendant. So we should always err on the side of keeping information outside of the public sphere. Why? Because if the information gets out publicly, it does have a tendency to taint the jury pool. The situation has changed dramatically throughout my career. 30 years ago, if you had a string of newspaper articles about a case in your local community, you had a pretty good chance of getting the case venued out of the county because of the pre-trial publicity. But two things came along that have had a permanent impact on that. The O.J. Simpson trial, with its notoriety and its combination of being involved in a 24/7 news media. Mm-hmm. So with that interest in grabbing news and putting news out there and getting information, we've seen this incredible push for more information about a sensational national case. More information. We have to feed the public interest. And that's dangerous. Even though the public wants to know, we have to focus on the trial being correct. Now, you said there's a gag order. Why can the prosecutor make a comment? And you've done an excellent job of analyzing it. The prosecutor or the side that is wanting to clear up the misinformation can arguably do just that. Make a statement, clarify a misinformation. And the examples that I would use for that would be you have an investigation going on a mass shooting or any type of shooting, and the defendant is still at large, and someone might say that they're targeting various people, and there's a panic going on in the community. I, as a prosecutor or police chief, may go out to the public microphones and say, that's misinformation. The information that we have is that this was an isolated incident involving these people. Saying that to calm the community, saying that to make sure that we don't interject bad information that could be harmful. That's just an example. So there is an opportunity for someone to go out and clarify the information. But even with that opportunity, you want to be careful about that, because you don't want to do anything that damages the interest of justice in a case. So it's a very solid standard. I've seen over the years both sides violate it. I'm particularly interested in the prosecutors maintaining the integrity of their case as a former prosecutor, I don't want to see a prosecutor take liberties with evidence in an effort to tilt the or stack the deck, if you will. So I think that a prosecutor has a greater responsibility in the case. If they're going to clarify information, they have to make darn sure that it's doing just that and only that, and not trying to do something that tries the case in public versus in the courtroom where it belongs.
Exactly.
All right. And so, as we mentioned, I believe the hearing on this is coming up June 22nd. I want to say, is that correct? Does that sound right? Okay.
Right.
Okay.
To rule on it.
To rule on that. All right.
KJ, I'm sorry. One thing.
ask-
Feedback. Can someone, if you mute yourselves, please, because this is feedback.
Sorry. Oh yeah. I'm sorry.
If you're not speaking.
Okay. So my question then for you, General Hill, is what do you with this preliminary hearing coming about? Who do you think has the better chance of? Do you think that the defense will be able to get this taken off of the death penalty? Because that's one of the things they want to do, correct?
Right. That's what the defense is asking for as a result of this. I think that's an unreasonable ask. I believe that the judge is kind of going to split it in the middle. He may say, yes, the prosecution took too much liberty, but I'm not going to remove the death penalty. The case is going to proceed. Okay. So again, okay, go ahead.
Yeah, I wanted to see, just from your experience, General Hill, have you seen something like this happen where they could lessen the charge, take off death penalty?
Well, that's very unlikely. I think what you have to look at is in a case like this that has a high profile visibility, and many people have formed an opinion on what happened or what's likely to have happened. The defense has got to do whatever it can. And what you're seeing is a checkoff list of can we do this, can we do this, can we do this, and they're going to do it, and that's their job. That doesn't necessarily mean it's going to be successful. And some people might say, "Oh, I'm appalled. They're trying to get the death penalty thrown out." Well, they represent the defendant. Their objective is to do the best they can to provide a defense or provide a reasonable outcome under whatever circumstances. And so if they identify something that the prosecutor gives them, even if it's minuscule, even if it's not quite legitimate, they're going to go for it. So we can't blame them for that. Just because they go for it doesn't mean it's likely. We're at a stage now where the case is still in the preliminary areas. The preliminary hearing to find probable cause, it's a lower standard. That's just to be able to say, yes, we can go forward and have an evidentiary trial. So as we're moving through these preliminary steps, you're seeing lots of information that seems like we're trying to prove the case. No, we're not in a mode to prove the case yet. We're in a mode to say, do we have sufficient reason to go forward at this point? And that's what we're looking at from a preliminary hearing standpoint.
All right. Ladies, any additional things you want to add there or questions?
No, again, motions are, and of course, AG, back me up or correct me, I'll say. Motions and responses to them are common in the legal process. It's actually how the process moves through the courts. Yeah. So, it's just part of the process. The defense can file motions, prosecution can file motions, the judge is going to decide, which is another reason why in some cases, particularly cases like this, when there's high stakes, it may extend the time of the trial start, which most judges don't want to do that. But because the motions and you have to rule on these motions by a certain time, because you really can't, depending on the motion, you can't really start the trial, depending on how significant and relevant is the motion is to that start of trial.
The trial is a contest. It's a contest between the state of, in this case, Utah, and the defense, and there's a set of rules that they have to follow. The state of Utah has established its rules and procedure regarding criminal trials. They're going to follow those rules. The judge is the arbiter of those rules, and both sides, I would say the defense has more leeway to stretch the rules. The prosecution is more limited because the prosecutor has to follow the constitutional dictates of how to process a case. So a prosecutor can't try to interject something into a case that might create a bad outcome. Whereas a defendant or a defense lawyer can take advantage of a situation and push that advantage on behalf of their client. I don't want to suggest an illegal motive on the part of the defense, but their objective is not, like I said, the state's responsibility is to prove that someone committed a particular crime on a particular day and hold them accountable. The defense doesn't have that responsibility. The defense's responsibility is to provide the best possible defense to their client that they can. Now, some would say the responsibility is to get the person off. That may be an extreme aspect of it. It's to provide the best possible defense. And if you win the case, you win the case. You can provide the best possible defense and lose the case, still be found guilty, but you put forward your best evidence, and the jury then makes that call on what must be true, and then the judge makes a determination of how to handle it from there.
Well, we have something. So recently, the prosecution is now pushing for Lance Twiggs, Tyler Robinson's roommate and alleged lover, to granted limited immunity. Take a look at this. This is clip 2.
His roommate, Tyler Robinson's roommate, Lance Twiggs, has been granted limited immunity to testify. But one of the things I think is kind of interesting about this story is apparently the prosecution doesn't want Lance Twiggs to testify in person. They just want this recording of an interview that police conducted or prosecutors conducted with Lance Twiggs. Why is that?
Yeah, again, no surprise here that they're granting him what we call use immunity, meaning essentially that whatever he told police during this interview, they're not going to use that directly against him. Doesn't mean that he can't face charges eventually, but just not based upon what he shared during that interview. It's unclear why it is that they don't want him to personally testify at the upcoming prelim, but they want to use his recorded interview at the prelim. But this is an indication that he will play a key role during the trial. We should expect that he will testify personally at trial. And we're now understanding from the limited information we have, we knew that he was aware of some of the plans, but it sounds like he may have had much more information shared with him by Tyler Robinson of what Tyler Robinson planned to do. And I expect him to be a key witness for the prosecution moving forward, which is why they want to be able to use him, and he would need a grant of immunity to do that, because otherwise we're going to be left with a situation where he simply says he's pleading the fifth, realizing that he might implicate himself, and so he wouldn't be useful at all.
All right. So let's get into this, General Hill. So this guy, this is the roommate and alleged lover, Twiggs, of the accused. Is now being granted limited immunity. He's described a week-long planning with the accused, weapon hiding, and instructions on what to do if police showed up. Surveillance video and witness statements are suspected to corroborate this. And now he gets off. He doesn't face anything for his part in his alleged part in this. Attorney General Hill.
Well, again, it's all preliminary, but that's what it appears to be. It would appear that he is being accused or suspected of having knowledge of the attempt or the desire to murder Charlie. Whether or not he both had the preliminary knowledge and believed that it was actually going to happen, that remains to be seen, but certainly there appears to be some suspicion that he had an engagement in it. It's not unusual for situations where you have a person who is charged with a crime and someone else who has some information but is not directly responsible for the actual commission of the crime to get some type of an agreement or a use immunity to help bolster the case. I mean, the prosecution's job is pretty clear. They have a dead victim. They have a suspect that they believe committed the actual crime itself. they're gathering as much information as they can to make that point. And they make decisions. They have to make choices in terms of do they have information on someone that could possibly be a co-conspirator? They have to determine if that's strong enough to move forward on that person too, or do they put all their eggs in the basket of Tyler Robinson, and this helps us get the information on Tyler Robinson, and he's the one we're after.
Yeah, I had a question too for AG Hill. So during the preliminary phase, is it common or uncommon that if the prosecution or the defense brings in an actual witness, not just a report, doesn't each side still have the right to cross-examine, I guess, that person?
In a preliminary hearing, not necessarily. In a preliminary hearing to find probable cause, that's the state's responsibility to put enough information before the judge to determine we can go forward. The defendant has no rights in that preliminary setting.
So we're past that part, right?
From what I understand, you're still engaged in that. You still have a preliminary hearing coming up, I believe, in July.
Right.
Not
July
for probable cause. He's
10th.
already been indicted for. He's already been indicted in the probable cause. He's already past that.
As I understand it, he's been charged, but
Okay.
under Utah standards, there has to be a preliminary finding in order for the charges to be further maintained. And so there's a preliminary hearing coming up. In my state, we call that a probable cause hearing.
Okay.
That the state is allowed to provide information to the court, including information that might not necessarily be admissible at trial. It could be hearsay. It could be all sorts of other information. But it's to get the court to grant the ability to hold the defendant on bail, to require the defendant to answer the charges. So that's a different matter. So these are still preliminary matters that are going before the court.
So, okay, I have another clarifying question for my understanding in the process. If the probable cause hearing has not happened, then how do we have a trial date set, and how come he's still being held already? That's what I'm not understanding then.
They have probably have probable cause to hold him. They have a preliminary hearing to authorize the state to proceed with their charges.
Okay.
Yep, and this is a big hearing coming up. It's July 6th through 10th.
Right.
And so prosecutors must show, as you mentioned, AG, probable cause. And again, that's not guilt beyond reasonable doubt. They have to show it via evidence, like the surveillance, forensics, the witness statements, and it's going to be public, which the judge has denied closure. So, folks, we're going to bring this to you, this hearing. The defense wants portions sealed and more live testimony, but it looks like this is going to be for the public.
Yeah, this
what
is going to be a big one.
on that, AG Hill? Do you think it's the prosecution or the defense that all of this is public?
I believe, in my view, the process should always err. The process should always err towards providing protections to the defendant, and that we'll see what happens. I mean, we don't want excessive information about the case to get out to the public, and then again create the public view and impression that the defendant is guilty, and then you bring in a jury panel, and that jury panel has been influenced by all of this information that's going out in these preliminary hearings. Now, you say, well, the jury pool, how could they possibly not know about what happened to Charlie Kirk? And that's a pretty likely scenario. But it's incumbent upon a juror to advise the court that either they don't know anything about the case, they haven't heard about the case, or they've heard about the case, but they have not formed an opinion on the guilt or no guilt of the defendant based upon what they've heard. The less that they've heard, the better that they can take that position, and the closer to a fair trial that you have. So yes, we as public want to know every little detail and every little tidbit, but if I were the judge, I would want to place as much limitation on the release of information in a preliminary hearing as I possibly could, so that I can help preserve that opportunity for jurors to have the clean slate that we're looking for. Ultimately, we want to try this case once. We don't want to have a mistrial. We don't want to have a bad trial. We want to have a solid trial where the right information goes forward, where the wrong information doesn't come in, and a jury has the best opportunity to make a genuine determination of what occurred. Not, oh, we saw this on TV, or I watched this podcast and these folks said that. That doesn't count.
I have one more question before we let Attorney General go. I have one more question. I know we're not in that part of the trial yet, but exculpatory evidence. I know that the prosecution has to, I guess, disclose the evidence so that the defense can have a chance to make a proper defense. But does the defense have that same, I guess, responsibility if they have evidence that will, the exculpatory evidence? That's what I'm not sure. Do both sides have that same responsibility, or is it only one way?
Exculpatory information is information that would tend to lead to the defendant's innocence,
okay,
or non-accountability for the crime. The defense does not have that same responsibility. So the defense, for example, not in this case, you can have a case where the defense lawyer may know that his client is guilty, but he still has a responsibility to protect his client and make sure that his client gets the fair trial. So he does not have a responsibility to go to the judge and say, "Hey, judge, my guy did it." So it's a different responsibility. The state has a much stronger responsibility and should have a stronger responsibility, because the state of Indiana is charging an individual with murder. They're taking someone's liberty away, and in many cases, or in some cases, taking their life away. With that stake in play, you want to make sure that the state has a very high burden to move forward, so that when they're successful, we can step back and say we had a fair trial, everything that was done properly, and we can live with the just result.
All right. Well, thank you. We know you got to go. Thank you for being with us.
Well, thank you for having me, and I enjoyed myself.
Thank you.
All right. We'll certainly have you back on before this case is concluded, I'm sure. All right. Good night.
Good night.
All right. So, folks, as you come in, hit that like button. It helps to get this video out in front of a wider audience, and we appreciate the support. As you know, we are a new channel here, The Right Verdict. You can catch us every Thursday night at 10 p.m. We're your late night snack, okay? And folks, your super chats, they go a long way in keeping us online. We appreciate the support. Again, we are a new channel, so your super chats are really needed right now. So if you guys have it in your heart and your pocket to super chat us tonight, we greatly appreciate you. I know some people have said there's been a lot of commercials coming on. We're going to look into that and see what's going on with that. Do apologize. I don't know if it's because we're new or what, but we'll hopefully have that fixed by next Thursday. So ladies, the breaking news out this week, and I know we kind of touched on it a little bit with this case, is the immunity of the roommate, Twigs. And folks, this is what people are saying. It could really blow this case wide open. The whatever his testimony is, the information that he may have. Nicole, do you think this is going to be a blockbuster for the case? What are your thoughts? Oh, you're muted, Nicole.
You're still muted, Nicole.
Sorry, because it was the whistling. But at any rate, this is going to be great for a lot of reasons. And there are a lot of legal pieces to this. As you know, they were just a cohabitating couple. Perhaps, rumor has it that this was his boyfriend, whether he's a furry or not, none of my business. But, they were a cohabitating couple. So they don't have the same protections they would have had if they were a husband and wife. Pillow talk between them when you're married, you're a married couple, that is confidential. They can subpoena you and ask you about it. Say, no, that was a private conversation between me and my spouse. I don't want to divulge. Here you have two young men, playing house in an apartment, sharing thoughts, sharing ideas, even through text messages. You see Robinson confessing to Twigs, saying, yes, I did it. So when the police sat him down and took his cell phone, they got copies of those messages, which have already been leaked. They leaked maybe, I think, in April, March or April, earlier in the year. With all of that said, he gave a comprehensive interview during that interrogation. And there's something in that comprehensive interview that the state wants people to hear, but they don't want to hear it through the very sensitive mouth of this guy's lover. They want just the cold, hard facts of what he said in that interview to be brought in. And this is why he has limited immunity, not full transactional immunity. This limited capacity, what they're saying is, this little bit of information that we're going to extract from you, whether or not you plead the Fifth Amendment, we're not going to prosecute you. So your Fifth Amendment challenge is overcome. If you do not testify, we will hold you in contempt. Make no mistake, you will sit in jail until you testify, but we won't use that information against you. Now, if there's some other things that come out down the road, they reserve the right, to hook him up for whatever else he's done, but they cannot use the information that's in that report that they want to use so bad in this trial against Twiggs. This is going to be very interesting. It's going to be interesting for a lot of reasons. These text messages, the ones that have already leaked, are absolutely damning. He says over and over again, yes, I did it. Twiggs asks him straight out, did you do this? He says yes. He talks about hiding the rifle. He talks about having a towel, how angry his father is going to be. And plus some really mundane things that couples say to one another. So there was a lot of immediate emotion, and those text messages did lend itself to Twig having some foreknowledge of what was going to happen. So I'm very interested to see what this report says, and why the prosecution is probably going to fight to the death to have it put in.
Wow. Shelley, what are your thoughts on this, his testimony, and how it will impact the prosecution and the defense?
So are we talking about the report that the prosecution wants to read during the preliminary, or are you talking about just in general during the trial?
I'm talking about the fact that this guy, Lance Twiggs, which, as we mentioned, is the alleged lover and roommate of the accused Tyler Robinson. He's received limited immunity after telling investigators, allegedly confessing to that Robinson allegedly confessed to him about killing, hiding the gun, ditching his clothes, and warning him not to speak with the police. Mm-hmm. What impact do you believe that may or may not have on the case?
I mean, of course, I think if he testifies, I think it will be significant against the defense. However, I'm not too sure about Lance Twiggs being able to give, I guess, sound. I call it sound testimony, sound and consistent, whatever way. I'm not. He's a little shaky to me right now. So
no, how so? That's what I'm trying. You mean
I don't trust that he is maybe mentally or fit for testifying. I'm not saying that he needs to be an insane asylum. That's not what I'm saying. I don't think he's mentally or emotionally stable to testify. I'm just not. He just doesn't come across to me as I'll say credible for legal purposes, credible witness. I just don't. I don't know. Right now, we don't know much about him other than those messages that are listed in the charging documents and things like that. And that's pretty much all we know. And what's been put out, I guess, on social media, true or not, I don't know. He just does not come across to me as reliable. That's what I'm looking for. A reliable.
Oh, okay. So
that's what I'm looking for.
So are you saying that when you say you're questioning his reliability, are you saying you're questioning whether or not he's going to go forward with the testimony, or are you questioning whether the truthfulness in the testimony? That's what I'm
questioning whether or not he'll go forward, and I'm questioning that if he does go forward, that what he says, whatever he says, is that you're going to be able to rely on it. I think whatever he says, I actually think he's going to say something that may help the prosecution, and he also can say things that will help the defense. That's what I mean. He's going to be variable in his testimony. So I'm not too, sure about him at least right now.
Well, I mean, Nicole, they have his text messages, so whatever he's going to say, they already know or have some type of idea what he can bring to the table because they got his text messages. What are your thoughts there?
Well, they have his text messages and everything that he said during the interrogation. And that's the part that they want to bring in. So, if they call him to the stand and he'd rather go to prison and sit than testify, I can't see that from what the reports have been about what's happened to him in his life since his name was leaked. He no longer lives in the area he lived before. He's withdrawn even more so from his family and friends. Sometimes they say that he just kind of travels about. He doesn't feel connected anymore. You can imagine your very private personal life being blasted around the world. I don't think that emotionally he was ready for the world to know that he is a furry. You know what I mean? I don't think he was ready for that. I don't think he was ready for the world to know that he had all kind of sexual deviancy and those type of things. So having that happen to you in a very public kind of real way is devastating. It kind of just pulls the life right from under you. This guy can't even go to the gas station without people making videos of him. It's like a unicorn sighting. Oh, that's the guy, So there's a lot of moving pieces to that, death threats and the like. But I think Shelley's right. I think he's not going to give reliable testimony for a lot of reasons, not only because he's going to want to help his former lover, but emotionally. He just doesn't have it to do. I mean, his life has been turned upside down. He's been publicly shamed, dragged for filth, and all those other things. This is why it's so important for the prosecution to get the report of what he said, admitted into evidence. This hearing that's coming up July 6th through 10 is not going to give us every single thing that the prosecution is going to put on their case, but it'll give us a better understanding of what they have that they think is damning enough to cost this young man his life. And I think that's where you're going to see the media just kind of go for a feeding frenzy on witnesses that we know are going to testify like Twig. I mean, if he thinks his life is hellish now, he's not seen anything. He's not seen anything. It's only going to get worse.
Yeah. Well, before we wrap up, ladies, I want to talk about, if we could, just quickly, the strengths and weaknesses from a legal lens for the prosecution and for the defense.
Well, before we do that, we got super chatters.
Yes, okay.
Hi, everybody out there tonight. Look, I know we jumped right in, and this is a really, really important, significant, deep, going to be emotional case. So we jumped right in. We did not forget you. So we want to thank you for stopping by. Thank you for your super chats. And we do have some here tonight, a couple here. We have Laura. Thank you, Laura, for joining us. There we go. It says, I have resigned that I will never know the truth about Charlie. He is so needed today. I hope you ladies can come to Boston soon. Would love to meet you. Oh, that's sweet. Yeah.
Yeah. I didn't know she was. We got us. We're working on it.
I would want to get there because I want to go to some bar where everybody can know my name and cheers.
Yeah, we're working on it, Laura. We're hoping to be there before the end of the summer because I want a lobster roll.
Oh Lord, I'm not lobster, but okay. Scrapping Beauty, thank you for your super chat. When you take the liberty to take another's life, you take your own too. Yep,
absolutely.
So, yeah. Yeah. So thank you all for your super chats, but don't forget, hit that like, share, and subscribe, and the notification bell. Remember, this is a new endeavor for us. We are enjoying it. We're learning. We're discussing, and we're kind of focused on this channel. Not kind of. We are on this channel. We're focused on the legal aspect of many cases that we're going to talk about, and some not so legal, just funny ones like the body cam one we did last week. Go back and watch that. That was a little lighthearted, but it still has some legal purpose to it. But hit that like, share, and subscribe. This is the right verdict, and you are in the right place.
Right. You got another one, Shelley.
We have another super chat. Thank you. 3 equals 1. Thank you. Hopefully, true justice will prevail in this case. Thank you so much for that.
So gracious. Yeah. Thank you so much.
Yes, indeed. Thank you. All right. So, ladies, what are the strengths and weaknesses you think from the prosecution and from the defense? So start with you, Nicole.
I think the prosecution has really good, solid evidence. As I tell everybody, and I tell politicians, people who are running for offices all the time, what you say in a text message will come back to bite you in the butt. It will absolutely come back and bite you in the butt. And this is what we're seeing, Robinson doesn't have to confess now, but he confessed when it happened. Not only to this guy, but apparently to a couple of other people. So this is going to be really strong evidence for the state. The behavior of the way he surrendered, the things he said to his parents, the things his parents said to the police is also very strong testimony. Because as a parent myself, to turn your child over to law enforcement, knowing that your child has committed this kind of grave injustice against other mankind takes a strength of character that some parents don't have. Some parents would have packed him up and sent him, to a country that doesn't have extradition with the United States and said, unless you're going to take the death penalty off, I'm not bringing my son back. So there are lots of really strong testimony that's going to come in from that perspective. From the weakness perspective, social media. There are a lot of people poisoning the jury pool. There are a lot of people asking questions that, at least in their mind, are legitimate. And it's only because they haven't seen all the evidence. They haven't seen all the evidence. And so they're making judgments based on limited information. And by doing that, they're tainting the jury pool. And that's always a tricky thing for the state, because it only takes one person. You can have 11 people that's saying guilty is the original sin. And there's one person going, I like the way he parts his hair in the middle. He's not guilty. And that's all it takes is one person. Now, from the defense standpoint, they're going to have to overcome what he said, how he said it, and when he said it. These excited utterances right after the event happened are absolutely damning. Before he had a chance to make up a story, before everybody got together and came up with a plan, he made some statements that defense are going to have to overcome. I think the strongest point for the defense is that he cleans up well. He doesn't look like a murdering monster. We talked about this when we talked about Carmelo Anthony, how the vision of them changes from who they originally were. This kid who was living with this furry dude and doing all kind of sexual perversion in the state of Utah, of all God places. You look at him now. He looks like any other Mormon kid, squeaky clean, hair parted and combed neatly. It's going to be a good thing for him to look like people's grandsons, people's children, people's nephews, the kid next door. I think that's going to be a very strong point for the defense.
All right. Shelley, what are your thoughts on strengths and weaknesses?
Right now, I actually don't have any weaknesses, and but I have strength, and the strengths are actually for the whole process, from the court, the legal, our system of the adjudication, if you will. So those are the strengths, and the strengths are distributed amongst the judge, the prosecution, the jury, and the defense. And those strengths are going to have to be balanced out each other as the process goes on. Now, I may have some weaknesses later as I hear more evidence, right? From the defense, but right now, or from the prosecution, whatever the witnesses and the evidence demonstrate. But for now, I am, I guess, on the whole of the strength of the process. One thing I will say, or two things very quickly. I think it's also a strength and a credit to the judge to have this case being broadcast or have the cameras in the court. And I also think it's a credit to the judge that, he seems to be in the preliminary hearing so far. He seems to be balanced. He seems to be open. He seems to be very professional and respectful to both sides. So, and what I've seen so far, when he gives his information or when he's speaking from the bench, he presents, he'll give his, whatever the reason it is, he'll give the rationale, he'll say this, and he also presents the contradictory side that he has to consider that pushes back even against whatever rationale he's giving. So I like that. I like that process. It shows me, at least right now, that he is impartial and he is adjudicating this process to the best of his ability. So right now, I just have all strengths.
Do you think we're going to get some OJ sensation as soon as they turn the cameras on? That I think that's everybody's major concern when you talk about, at least from a defense standpoint, when the cameras come on. Attorneys are people too, and some of them they like to shine. I mean, when you take a look at what happened in the Rick Chow case, that defense attorney, when I tell you he put on a clinic, he was sitting in the jury box. He was sitting in the witness stand. He was all over the court. He had on his, haberdashery made suit. He did the whole thing, and he out-charmed the state.
That's always a possibility, especially when cameras are on. But it's, I guess I would say, sort of what AG Curtis was saying. You know, you have to give the best defense, and if that's going to be your defense or part of it, you know, he didn't do anything, as far as I understand. He didn't do anything that would be contemptible, because the judge, right, the judge would have called that out, right? So, hey, all is fair in love and war. All is fair in the courtroom.
You know, all I can think of is Marsha Clark, how she went from, in that OJ trial, she went from the curly perm to a blowout because she was dragged on national TV for looking like a chia pet. I wonder if we're going to see any of that in this trial.
Well, we're going to see all of it, because, folks, we're bringing all of it to you right here. We're going to live stream it. Once they turn on the cameras, you can get it all here. You don't have to go anywhere else. So if you've been watching it on Court TV, Law and Crime, and wherever, come here. We're going to bring it to you live as it streams out, and then we're going to break it down with our analysis. All right. We are going to have subject matter experts, you know, attorneys, police officers. We're going to have them run the gambit, so you can get everything you need about this case here. And one thing you're going to get here that you won't get anywhere else is, you guys know, we're going to give it to you raw. All right. We're going to give it to you raw, and we're going to bring to you the truth. So definitely, and you guys know you can trust us. We're going to give you some you know, entertainment too with it, probably, you know, our little sensational personalities with it. So definitely continue to like, share, and subscribe. Don't forget to hit that notification bell so you know when we go live, because when it comes to this, this news and media can come off, you know, at any time. So if you hit the notification bell, you always know when we go live. All right. That does it for us tonight, ladies. Again, we'll see everybody next Thursday.
Good night, everybody. Thanks for
Good
joining
night,
us.
everybody. Thanks for staying up late with us.
Yes, indeed. Thank you.